Okay. Guys ready? I'd like to call to order the August 16th, 2023 Ethics Committee meeting. We'll start with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation,
Under God,
indivisible, with liberty and justice for all.
All right, can I have a motion to accept the meeting minutes from August 9th?
So moved.
Do I have a
Second.
Okay. Luke will say who's first or second.
Neil,
Any amendments?
No.
All right, all those in favor?
aye.
And I abstain because I wasn't here. Great. Under old business, as we're getting closer to this process, we need a drop box. So Naomi, do you know how I can go about getting the approval to stick a drop box outside? Would I need to go to the selectmen or?
Dropbox for.
So if someone wants to drop off the inquiries, complaints, we need someplace where they can do that.
So there's two boxes out there. Right now, one goes to the clerk and one's for tax payments. If they stuck an envelope and wrote Ethics Committee on it, we would get it to you,
Could you,
sealed. I just don't know, there's one here and one here. I don't know where you're gonna put it.
could you put a label on one of them that said, "and Ethics Committee"?
Yeah, probably ours is easier because it's only used like twice a year,
Okay,
and theirs is used all the time.
okay. And so then I would just connect with you to get those?
Yeah,
Yeah.
yeah, and what we can do, I think, and where it just showed Neil, if you stopped during the day, we can make a mailbox on the wall and
Okay.
stick it in there.
Great,
I'll have to just figure out what's empty right now.
okay.
So if I add it to the tax collector box, just say tax collector and ethics.
Mm-hmm.
That work for you guys? Awesome.
There's nothing unethical about connecting ethics with taxes.
Taxes are very ethical. We support our government, right? Okay, that's easy. And then the main topic for today is the complaint process, and I think you guys had started that last time. So, does anyone want to do a recap, or, so, I know that Neil, you have a form of what they did in 2006.
If you'll turn to number 5.
Okay. Oh, yeah, I did see this one.
Okay, this is what was, I made no changes here, except the date, which is incorrect. And this was what was done by the 2006 committee.
Okay. So, notice of hearing.
And this is simply how the committee proposed to conduct hearings. To the best of my knowledge, they never had any complaints filed, and they never conducted any hearings.
Right. Okay, so if and we need to read through that, obviously, but even if this is perfect how we want to do it, we still need that process of how we get to the hearing, right? And that's what y'all have. No, you don't have. Complaint process to be determined is what I saw at the end of the internal process flow. And so with this then, sorry, I'm pointing to things that doesn't help y'all. So it says that the internal process flow for the exit committee at the end, complaint process to be determined. So if we're reviewing each thing, we determine something's a complaint. Then there is an investigation of complaints paper that was revised in 1006. Did you make copies of that one or no? This one. Yeah, yeah, this one right here.
I gave that out before, but
Yeah.
that's not included in the packet I
Okay.
just gave you.
That's fine, I'm just, in my head, I'm process crazy, right? So we'll do a read through, we decide, yes, this is a complaint, then we go to the investigation of complaints, and the end of that, we go to a hearing, right? Would that be the,
Right.
okay, so, do we want to start with a hearing since we have historically?
So what I would suggest is, I have seen these that Neil provided before, and what we discussed was, these are more about a general, here's the evidence, here's the overarching cloud of what's admissible or not under the statute.
Right.
It doesn't really address how you conduct the hearing, which was what I sent along, was
Right.
the process of how to conduct the actual hearing.
Right.
How do you do witnesses, is there an exchange of evidence, those sorts of things. So I think that at the end of the day, what we're probably gonna do is end up with a melded document of both of these.
Right.
One that covers the.
And you're
here's the
right, because
rules.
this says rules, it doesn't say process.
Right.
And you sent a process that may or may not work so now what was your process from?
Internal trial committees for the federal union I was part of.
Okay,
Although I did redact I hopefully
Sure,
redacted
yeah.
all of the relevant stuff. It's a case I won.
nice. So, I'm looking for guidance from y'all. We can start with building up that process, adopting the rules as they were, because those are based on, well, case law from 2006. I don't know if the laws have changed around that. Or a high-level process and then get into the meat. What are your thoughts? How do you think?
Well, what I think is this document is guidance to the committee.
The investigation of complaints?
The,
No.
no, the rules
rules,
regarding the
okay.
conduct of the hearings.
Yep,
To me, feels like guidance to the committee rather than an explanation to the participants. What the processes I've been involved in have been, somebody files a complaint. There's an initial review of the complaint to find out if it comports with whatever the rules are that they allege violated, and then you have to communicate with the parties about setting up a hearing
right,
and what happens in that hearing.
right.
And so that's,
So the investigation and complaints by the Weare Ethics Committee, I don't know if you have this one, it says, any person can submit a complaint alleging violation. Committee won't consider any violations that occurred before the adoption, right? We talked about that. And then within a reasonable time of the receipt, the Ethics Committee shall forward a copy to the complaint and supporting materials to the subject of the complaint. Shall make a preliminary evaluation in any response, incident, or whether the complaint establishes probable cause, whether it should be dismissed or there should be further proceedings. If the committee determines there's probable cause to believe there's a violation, subject to the complaint shall be offered an opportunity for a hearing before the committee. So it's a sort of high-level process, but not how we'll do it. That sort of, I think that's closer to what you were talking about.
that's guidance to us on,
Right.
and just an explanation to the public of how we're going to proceed. And then, of course, when you get to a hearing, you have to be more
Have a process,
particular.
correct. And then it says the existence and status of this complaint is public data. All other information regarding the complaint shall be considered non-public while the matter is under consideration. So will remain so until dismissed or until the committee determines the RSA provisions no longer apply.
Which is an interesting conundrum in that, as I read the RSA, it's required to be a public hearing. So how do you
Yep,
apportion parts of that to not be publicly available or exposed until the decision is made?
right. So, so I'm just gonna make a list because I think, so we need a high-level process for us to agree on, right? We need a process, a description of the process for the public, right? Because that's what you're saying, is they need to know what to do, what to expect. We need to understand the legality of whether or not a hearing is public or not, right? That's your concern. And to be fair, this is written about RSA provisions from 2006. Laws certainly could have changed since then, right? So one of our steps may be to speak with our attorney and make sure that we're legal. I think we've talked about that a few times now, right? Then we need a hearing procedure, right? I mean, right? And we have the rules. Just to make sure these rules are still current, because it was 2006. What else do we need? Are those the big things?
Those are some pretty big things.
They are huge, right? So, So do we want to start with how we get to a hearing, that process, since we have the inquiry process, right? So it's pretty close to that, plus who do we need to notify? Do we have further investigations before the hearing? Do we need the complainant to give us feedback, or we don't want it all in a hearing? Like, there's that piece before we actually start the hearing, right? So do you have thoughts on,
I think this document, the rules regarding the conduct of the hearing, with some adjustments just for, I think this was clearly written by an attorney, but I think we have to be cognizant that we are not conducting a legal trial. And so, there's discussion of the burden of proof and the clear and convincing evidence versus, preponderance of evidence, all that sort of stuff. I think that's more advisory to us than to the complainants. So I'm not sure to what degree you have to have a public-facing document that says, here's what we do in the event of a trial. What my experience is there's a set of general rules that everybody sees. Here's the general concept. Once it's determined, after a complaint comes in, the committee considers it and says there's enough here to move forward with, then a separate set of hearing procedures tailored to that event go out. And that you could publish that, we're having a hearing on this date, here are the rules of the hearing for this event. They may be different from time to time, depending on, a number of circumstances. But so I think that you have to have some flexibility in the process
right?
versus the overall rules. I'm not sure if I'm being clear, but so I think they're separate. I think we could establish what do we see as being applicable under the rules, and then
Start with what we have.
start with what we have, and then consider a separate, what happens if we have a trial? Here's
Yeah.
how we would
Okay,
hold that and conduct the actual hearing. I
Okay.
said trial, I
Right.
meant hearing.
right, so back to Neil's document 5. So, the notice of hearing, the copy of the complaint and the supporting material.
And that's an interesting one here, because this assumes, under notice of hearing, it assumes that the committee was provided with a copy of the complaint and all of the supporting material. It's, the respondent may also have material. And
Sure.
so the question becomes, the way the process that I'm familiar with would require the two parties to exchange that material before they came, so that nobody's being caught flat-footed in the hearing. So you'd know what you were accused of, you'd know what they were referring to, and you could come prepared to discuss that.
Sure.
So this, the way I read it, right now, you would only have the complainant side, and that's what you would share.
Right.
And so how would you balance that such that the complainant might see whatever additional evidence
Right,
and may or may not affect their decision to move forward?
yeah, I think I'm thinking about court cases, but then I'm also thinking about sort of HR complaints. So when someone complains about, this is where Eileen is really helpful. When someone complains to HR, then they go and talk to the other person. There's a middle person, so it kind of feels like if there's an ethics complaint, there's people butting heads. I don't know if they should be the ones who are sharing documents in that case.
Well, they can do it through the committee. That's normally the process, that the party would send it to the committee, you could send it to them, and then ask, do they have any, and then you give them whatever the amount of time is. Do you have any documents that you want to share or are preparing to bring, that sort of thing?
Right, and that gets to that process that I'm talking about. Before we decide, yes, we need a hearing, in the hearing, there's some, that piece is still foggy to me. But we can jump to, assuming both people have provided information.
Okay.
We're gonna make sure both people have everything we have, right?
And this is going to the RSA 91-A, the next line, all hearings and pre-hearings and informal conferences shall be held in compliance with the right to know law. So there's an assumption that there would be some pre-hearings, I assume, in, you know.
Well, there's talking about pre-hearings, under the heading, pre-hearing and other informal conferences.
Right.
Right. We may meet with the parties for a pre-hearing conference to aid in the disposition.
Right, and that's where, and maybe that would be the place for the exchange of information, but it's also an interesting question whether you would host that pre-hearing with both parties at the same time.
Right. Because then
I assume you would.
it's basically the hearing, right? I mean,
Maybe. You would have to structure it such that you would be very clear about, we're not here to have the actual hearing, what we're here to do is agree on. For example, one of the things that what has to be agreed on is this is the charge, this is the complaint, you know, and so that both parties clearly understand that, and you don't spend most of your time establishing, well, that's not really what my complaint is more X. And so, you know, the parties would stipulate this is the complaint prior to getting to the hearing.
So, you're envisioning a situation where A files a complaint against B, and B does not know this,
Right?
right.
okay? And the committee gets this and determines that on its face, it's an appropriate matter for the committee to determine, and let's ignore the reputational damage issue and
Sure.
so forth. So it's going to be a public hearing. At that point, doesn't the accused party have to be notified and
Yes.
given a copy of the complaint and ask if he or she wishes to provide any documents in response?
Agreed.
Yes.
Okay, and now, once we get those documents, well, that person, I guess, would send the documents both to the complainant and to the committee,
Yeah, usually to the committee, and then the committee would share it with the complainant.
or
Right.
that way if you
Right.
wish. So, at this point, nothing's been scheduled, but complaint and response have been exchanged. Okay, that's how you
Yes.
envision it. At that point, my guess is that in almost every case, there would be a pre-hearing. You'd want to get the parties together to make sure we're all clear about what the issues are, and that everybody, and that we're trying to narrow things down as to what the, if there are factual issues, what the factual issues are. It may be that there are no factual issues. That is, the parties are agreed that this is what's happened. I think it's ethical. You think it's not ethical. Okay? So we want a determination. In which case, we wouldn't have to have a hearing,
Right.
because there's no dispute as to what happened. I take it the hearing is only to determine what happened. And after we've heard that, then I guess we have to do this publicly, decide what the facts are. A said X, B said Y, so we said whatever it is. So we make that determination using presumably the standard that's in here, whatever that may be. And then we have a further discussion about whether those facts constitute a violation of the ethics guidelines.
Right.
After we've done that, we write up a summary of our discussion. Everybody's heard it, it's been recorded. We write up a summary of our discussion, and I would assume announce that at the meeting, at some meeting, and send copies to the complainant and the respondent.
There's a step that I think is missing, at least from my experience, and that is that, so you go through the pre-hearing phase where you're exchanging information.
No, we've exchanged
We've
information.
exchanged information, we know what's happening, and then there's the hearing, you would have the opportunity to bring witnesses if there were such,
If there were a dispute of facts.
if there's a dispute of facts, right, that sort of thing. And then, so you have whatever, the exchange before the committee. It would be probably unwise for the committee to make a determination at that meeting without having time to digest and consider. So what normally would happen would be that the committee would come out with a sort of a position, well, let me say this first. What often happens is after the hearing, you give the parties the opportunity to submit written positions. Each party can submit a written position to the committee that's a summation of their, whatever, their position. And that just sort of goes on to the record, and that gives the committee additional things. It doesn't have to happen, but you'll see in the process that I submitted, it's possible for the committee to ask that if it feels it would be helpful.
There's a problem. There are some people who are very adept at conveying information, other people are not as adept.
Which is also something that's considered in what I sent you, and that is, and this is something we're going to have to consider, do we require individuals to represent themselves, or are they allowed to be represented by another party? And if so, does that party have to be a member of the town, et cetera? And those are, because exactly the point you're raising here is not everybody can, stand up in front of a microphone and articulate a position soundly. What the processes I've been involved in have allowed for the substitution of a representative for the complainant. The complainant has to be there, or for the subject of the complaint. They have to be there, but this person would act on their behalf. They would not then be able to jump up and say, they have to sort of say, this is my representative, they're speaking for me. So, for example, in challenging submissions or cross-examining witnesses, that would be the person who did that on behalf of the individual. So, again,
You're making this into a legal process, and,
this is,
Yes,
imagine just turning it into a legal process.
but you're making it more so. As I read this, they tried to avoid that. For example, argument at the end. Oral argument other than a brief opening and a brief closing statement shall only be permitted in exceptional circumstances.
So that is an interesting position, because what that says is you can't argue your position. So all you can do is have a brief opening and then what?
Brief closing statement, that's what they were saying.
Well,
I
so
think
then
you
it's
did
all
it.
no, it's all the documentation, right, that they've provided, right? So,
Right, but
And
often,
witnesses.
and witnesses.
but often in these cases, it's not necessarily a document-heavy situation. It's going to be, a recounting. And so
So
I don't know how you get around
A
oral argument.
files a complaint, which states a whole series of facts and says this is unethical. And B responds and states, either agrees to the fact and says it is ethical, or says, no, the facts are different, and I conclude that it's ethical or not ethical, presumably ethical. And then we have a hearing. Now, the way this was set up, A would have a chance to state orally what he's already presented in writing, and he may be better orally or better in writing. And then B comes along and does the same thing as an opening statement. And then they present, or we call witnesses. I'm assuming there's a factual dispute.
Right, and so normally, or again, not normally, in my experience, what would happen is that the charging party would proceed first. They're the one making the accusation, and they would bring forward any witnesses which would have already been notified to the committee. I'm going to bring witness A, B, C, whatever. And then those people would come forward. In order to elicit information supporting their side, they would ask questions of the witness.
They would or we would?
They would first, and then.
That's
and
not the way this is set up.
I understand, and
Okay.
what I'm saying is if you haven't had the opportunity to read what I sent, and that's why we were covering that. This doesn't cover the hearing part of the meeting. It doesn't go into the detail of it. It gives sort of a general overview of burdens of proof and that sort of thing. But in arguing burdens of proof, there's an assumption that you're going to have people, presenting a hearing style discussion.
So question, so we're just talking about hearings.
We're on document number 5.
Thank you. And so the discussion is kind of,
Those are the notes I've taken
thank
so
you.
far.
So,
I relinquish my note-taking and
give
apologize
us
for my penmanship.
so basically the question is, we're gonna do a pre-hearing, It's gonna make sure both parties agree to, or at least understand what the two stances are, right? And, but we have a disagreement as to the facts, and then we proceed to a hearing, right?
We try to clarify and narrow.
Right, so at that point, when we start the hearing, we and each party has presented what their case is. So by the time we get to the hearing, they don't need to give us the case, right, because they've done it in the pre-hearing. So they're summarizing what their issue is. We're trying to get to the facts, so wouldn't we be then querying the witnesses as opposed to having them, say, lead a witness, maybe? I don't know.
Well, so again,
In your
we can
experience.
establish whatever
Sure,
we
sure.
want. What I'm saying is, so in my experience, the charging party would interview the witness first. Then the charged party would have an opportunity to interview with the witness. And then each member of the hearing committee has an opportunity to ask questions of the witness prior to being excused.
That's making it so complicated.
Once again, Neil, I'm just submitting what I was asked to last
No,
time.
no, no, I'm,
In a process. So I agree that the process I'm talking about is complicated, and I'm not suggesting that it ideally suits this situation. I'm just saying there are aspects of it that I think we need to consider. I am not wed to using the same process. It would be impractical.
I like Wendy's approach. We always have a pre-hearing. Okay? It's not optional. Well, we can make it optional, but basically, we're always going to have a pre-hearing. And we are going to elicit from the parties what the issues are.
The issues, but not the evidence.
Correct. And they're going to say, this happened, and this happened, and this happened, and we're going to ask them, well, how do you know this happened? Well, Jonesy saw it.
But that's the evidence.
Right.
And so
But
what I'm
Jones
saying
is
is you can't supplant the hearing with the pre-hearing. The pre-hearing is
No,
to order
no,
the
no.
hearing, right?
No, not at all, and I think what we can elicit, okay, these are the people who saw it, these are the people we need to get to come here to say, yes, I hear, yeah, oh, yes, I saw it, this is what I saw, blah, blah. But then we already know that the complainant and the defendant have already said, I can tell you it's not because of this person. My concern in this town, which I love very much, been here a long time, but if you have two people who are fighting, and they're each gonna ask a witness, you're my sister-in-law, you can't, like, they're not lawyers. So it just seems like it's gonna turn into Jerry Springer. So I'm wondering if we control that by we're the ones who are clearing that.
It seems to me that the best thing is, I think, to keep this as informal and as friendly as possible. And so, rather than have them battling each other, it's the committee that is interviewing the witnesses to try to elicit what the situation is, not either party. They don't participate in this. We participate,
At the pre-hearing? or-
at
In
the
the hearing.
pre-hearing, they've stated their case and told us who is going to be able to prove the facts, assuming that we don't reconcile the differences, that there is a difference. A says it happened, B said it didn't happen. And A said, I have witness, and B said, I have witness. So, okay, now we understand the situation, and we know who the people are. Then we have the hearing. At the hearing, we call witness A, he gets sworn in, and we start asking him questions. And we're finished.
Based on the information we
Based on-
provided in the pre-hearing.
Pre-hearing.
Exactly.
yeah.
And then we do the same thing with witness B, okay? Then we, according to this, we would give each party an opportunity to sum up
Right.
at the end, this oral argument thing. And then we're finished with the hearing. And then it's our discussion, and we have two things to do. What are the facts? We believe A, we don't believe B, or whatever it is. So we as a group, on a 4-to-1 vote, a 3-to-2 vote, a 5-to-0 vote, have determined that these are the facts. Okay? And then we have a discussion about whether that fact situation constitutes a violation of the ethics guidelines. We have our discussion, we come to a conclusion, we have a vote. And then we write our opinion up. Here's what happened, in our opinion, and this does or does not constitute a violation of Section 4 because.
So the pre-hearing would be a public meeting?
Everything's public.
Okay.
Unless we have to go, come on,
Non-public?
non-public, because there's reputational damage at stake beyond the fact that one person is going to find his conduct was unethical. That obviously damages the reputation, but I don't see how that can be avoided.
So I understand what your position is. I'm not sure that that comports with this document on this side, and what I'm specifically talking about is the Ethics Committee may direct some or all of the evidence be submitted in written form, but oral testimony shall be required when necessary to avoid material prejudice or permit full and fair disclosure of disputed material facts. That would be part of the hearing process, I assume. The actual hearing, not the
So-
pre-hearing.
The pre-hearing is like a pre-hearing conference, right? Where
Right.
you're trying to figure out the scope, how long it's gonna take you to,
Narrowing it
Right.
down till we
Yeah.
both
What the
agree
dispute
this
is.
is the dispute.
And
Yeah.
whether or not they can agree on some of the facts.
and how long it's gonna, how many people you need to call and how much time you need to set in your schedule to be able to deal with it,
Right.
right?
They are, but the point is, they're going to have witnesses, they're going to suggest that they have people who can prove whatever it is they think happened. But it may be that we think there are other people involved who neither one of those people, neither one of the parties wants to call.
Oh, now you're in dangerous territory.
Why?
When the committee itself starts determining who the witnesses are,
Yeah,
I think that sets you
we
up
need to
for
hear
a
from
pre-
A, we need to hear from C.
I think it sets you up for, for a prejudiced decision, because now you're not just hearing the case as an arbiter of the case, you're suggesting who the witnesses are and what the supporting or I forget the other word, issues that take away from the facts are. Our job is not to, provide the evidence, as it says in here, the burden of proof is on the charging party, not us.
So we're not supposed to get to the truth?
That's not a fair statement in considering what I'm suggesting. And what I'm suggesting is that wouldn't happen in any hearing process that I'm aware of. The hearing party, whatever it is, committee, the jury, the judge, wouldn't say, oh, well, you need to have this witness in addition to what you suggest is a witness, because the burden of proof is on the charging party. So if that charging party came in and said, my witness is A, but the committee said, well, we think we need to hear from B or C, and then B or C somehow takes apart the case, that now we are an active participant in the hearing, the substance of the hearing, not just in adjudicating, for lack of a better term, the outcome.
A is aware that a witness who he does not want to call might have testimony that conflicts with his witnesses. And B is not aware of this witness. If we don't call that witness, we are going to be perpetrating.
How would that work in any hearing that,
I'm not talking about any hearing. I had, as in a small town, we're trying to,
avoid the town being liable, I assume?
we want to get the truth out, the whole truth. And if, because one party, for whatever reason, doesn't present all of the witnesses that are relevant, we shouldn't be able to call them?
Well, I strongly disagree that the committee would call witnesses. We may, refer to the guidance of the rules that we're, adjudicating by, the ethics committee rules, and say, well, that's not relevant information. Or is there more relevant information? But we don't go out and investigate, on behalf of the committee, whether there are additional witnesses and whatnot. That's up to the parties. If it were, for example, let's look at what most of these cases are going to be, is somebody in town is going to say that somebody else in town who's in a position of some authority has violated a rule. I assume that those people, whoever they are, so let's say it's the Board of Selectmen, they have counsel. They have somebody available to them to help them in situations like that. The complainant wouldn't have that. So I assume that if it's an official, ethics complaint, we would have the whole case, but I would be really hesitant to have the hearing committee as an active participant in providing evidence for or against, because I think it sets you up for having whatever decision you make invalidated after the fact.
I don't understand that at all.
Okay.
I just, to me, the important thing is to gather all of the information that's relevant to understanding what the facts are and to reaching a decision. And if the parties, through
So,
intentionally or through their inability, don't bring to the table all of the witnesses who are relevant, we're going to reach a decision which will be laughable.
but we would also then be tasked with investigating independent of both parties on our own and presenting a third perspective, which would be unheard of in any proceeding that I'm aware of.
Well,
Could you give me an example of how we would be aware without us having to, what's the word, where we have to say we can't participate because we have a conflict?
recuse.
We can't recuse ourselves, but we know something, or we know somebody knows something. God, that feels like Facebook. How do we have that information, bring it forward and not have a conflict on our piece? Could you give me an example of kind of what you're thinking?
All I'm saying is if there is another person out there that overheard the conversation, I'm making up a situation. But neither party is calling that person.
How were you aware of it?
The person called me up and said, I want you to know, Neil, I overheard this conversation. And this is what happens.
I know, but at that point, then you've been compromised,
Not in
or,
the slightest. All I do is come back to the committee and say, hi, folks, I want to know that I got a call from X who said Y. I think he should be a witness. I'm not compromised.
If you know that before the pretrial, like the pre-hearing,
Depend on when the person called, yes.
yeah, I mean,
This is what's going to happen.
I agree, and I think that we have to refrain from actively participating. If someone were to call and say, hi, I have some information for the committee, then what I would say is, well, respectfully, that needs to be submitted to the committee through appropriate channels. It would be like witness tampering, not to dive too deeply into the news at the moment, but, if you're prejudicing the outcome by having a path to the committee that the other party doesn't have,
Both parties have this, as well as the public.
Anybody in town can call any member of the committee and submit any type of information that we would then independently determine is submissible for the hearing.
If somebody calls you up and says, here are the true facts, Luke, okay?
In a hearing. And there's already, we're assuming there's already been a
The
hearing
complaint has been
contemplated.
filed, and this may happen before or after the pre-hearing,
Sure.
or right up to the end of the hearing. People will get involved one way or another. For example, there will be a conversation on Facebook about this. And there will be information provided on Facebook about a different set of facts or a different perspective. And somebody else, because I don't do Facebook, somebody else will contact one of us and say, hey, there was this discussion on Facebook, and you guys ought to consider having
are
Jones
you
as a
looking
witness.
for us or are you looking for Naomi?
I just want to say hi. I'm the building inspector. Hi, Naomi.
Okay.
How are you doing?
Neanderthal yacht was the one.
Yeah.
So if someone calls you and says, I have information that's gonna help the defense, wouldn't the appropriate thing to see, you should talk to the defense and then they can bring you as forward as a witness, as opposed to we're bringing a person forward?
But that's true. You might want to do that if that were the situation, but in many cases, people are going to say people are concerned about the what actually happened, not whether whether it helps A or B. In some cases, they are concerned about whether it helps A or B. I just don't. I think it's very important in a small town that all of the information be on the table. And if the two parties who are contesting the issue, for whatever reason, don't have all of the information on the table, I think we all suffer. I think we'll make a decision that we'll regret, and the town will regret, and will look very silly.
Well, I don't mind looking silly, I do it all the time as a kind of a passing thing. But what I would say is, again, our role here is to provide a fair hearing to the parties.
No, then you and I have a difference there.
Oh,
Okay. That is part of our role. It's not our complete role.
in the hearing process.
The overall purpose of this committee is to make thoughtful decisions about whether certain kinds of conduct violated ethical guidelines. That's what we're supposed to do. And we need to make sure that the process enables us to do that.
Sure.
We can't set up a process where it may be that all of the relevant information isn't before us.
So,
And relying on the two parties and saying, as we do in the court system, because we have lawyers who are supposedly relatively equal,
yep,
using that model may not make sense for us.
So what I sent you, the processes that I've been involved in, did not involve attorneys. There weren't attorneys representing the individuals. These were lay people.
I understood, but lay people in the place of attorneys, or attorneys in place of lay people, are trying to win, are trying to get a result. We are trying to do what is right.
so question, so this, maybe this is an extreme, so you're saying someone reaches out to me and, to you and says, I have this information, you'd like the ability to pull that, to bring that person in and share
Or the
that?
other person they're referring to.
Sure.
Yeah.
So then, shouldn't it be a public hearing where anybody in town who has an opinion or has information could just come in and share it?
We could do that if you wanted to,
I
and you could
don't.
look at those witnesses and, well, remember, we're talking about information, not opinions.
But if it's anybody who walks off the street, you cannot pre-litigate what is an opinion versus what is,
But as soon as they start to speak, we can say, I'm sorry, this is not factual information, it's opinion, and that's not relevant for us, thank you very much. You don't have to let people speak just because you've given them a microphone if they're going beyond presenting factual information. There are many ways to do this, but I don't
Yep.
want us to hobble ourselves in such a way that we can't get to the truth simply because we have two unequal opposing parties.
And I don't want the committee to appear biased for or against either party. And when you cross the line of supporting information for or against either party, you have reduced your credibility before the public, because now you are acting as an active participant in the hearing and not the adjudicators of the hearing.
I think I hear what you're saying. Do you think that having, let's say, the town clerk or one of the selectmen come in at our request, not the parties, to present factual information is violating the rule that you just suggested we should be following?
I think it would really be dependent on the case, but in most cases, I do think that it's inappropriate for the hearing committee to call witnesses. That's the job, as it says here, the burden of proof is on the charging party. And now we are taking on the burden, as in some fashion, taking on some responsibility to either support or to, take away from one position or the other. And that's not our role here. Our role, I agree with you that our overall role is to maintain, the ethics at the end of the day. But I do not think we should be active participants.
okay, so Eileen's ready.
Just taking it all in. So I have two things here. One is because we're talking details of hearing, I want to go to 30,000 feet for a minute.
Yep.
And talk about the role and responsibility of each member of this committee in terms of people doing direct outreach about information that they may or may not have relative to cases that we may or may not be discussing. My recommendation would be, if anyone called me, I would say, I'm not able to discuss the details of this specific issue. If you feel like you have something that we as a committee need to know, I'm going to recommend that you put it in writing and drop it off so that as a committee, we can view it and make a determination. That would be one. Number two is, to Neil's point about bringing somebody in. I'm a trained mediator, I'm a marital mediator, and there have been times in mediation, right, where I am neutral as a mediator. I don't have a horse in the race. The horse in the race is the end product, whatever the end product is. That I have had to have consultation with a subject matter expert to educate me
Of course.
to be able to render whatever I needed to render to get to the end of that case. I look at that differently. It's not me looking for anything other than, please educate me about this framework, because I need to understand if this falls within the ethical guidelines, because I need to understand more about your process. It's a consultation about facts and process. It isn't opinion-driven, it's facts. And I think that's where Neil's headed, I'm not sure.
So so an example that comes to mind is somebody complains about the Board of Selectmen, for example. And so we don't understand the processes that the Board of Selectmen uses to come to whatever decision it was that they came to. And so, as you said, the committee might ask for a representative to come in and explain to us your process on this without crossing the line of, the particulars in the case. Absolutely agree that that is often necessary. But that's different from what Neil was suggesting, is somebody called him and said, hey, I have some additional information that you need to ask this witness who has relevant, to come in, and then we would bring in another witness to the events. I think those are distinct differences.
Yes, I agree. They are different.
And so I guess that goes back to you, Neil, Eileen is suggesting that it would be appropriate for the committee to have subject matter experts come in and brief us on processes or whatever. But what you were suggesting is that if we got a tip, for lack of a better term, that we could elicit that tipster or information from that tipster, a witness to come in and discuss during the hearing. Is that accurate?
Yes.
Okay, so one of the processes somewhere, some millions of papers, was there's this investigation period, right? Independent of pretrial. And so an investigation period, maybe we have extra people come and give us their feedback. They're not part of the hearing necessarily, but they could come, let's see, right, isn't there an investigation period that's before the hearing?
I think you're thinking of the investigation for
Written complaint?
not a written complaint.
Within 30 days of concluding investigation into a written complaint. So I know
Okay.
there's an investigation for that, but I also thought there was one for you complaint, written in writing, sending complaint, certify. A copy of the complaint, and seek so discussion. Okay, so you're saying we wouldn't have separate people come for other than process? They would come at the hearing point is when we talk to more people than the complainant and the respondent, right?
Right,
So then
and-
the question is, who can bring those people?
And that, in my opinion, Eileen is on point in that if we were to receive such information, we would direct them to the parties.
Right,
And those people would then be privy to whatever that information was, and they could present it in the hearing.
right, agreed.
But it would come to us as a
Body,
body.
Right.
not a one person, right? And that's really important on any committee
Yep.
that we do, that we speak in one voice. So otherwise, I have a friend with a relationship or whatever, and they know they can get to me, and they know how to spin me up, and they know how to influence me, and then I use my power to sort of bring that in, right? And so if they come and talk to us as a body, then the entire body can decide whether that information is relevant or not.
And both parties would now have public access to that information, so that would be equal for them. They both understand this was information brought to the committee, or brought forward.
Did you just agree with me?
No,
Then I didn't understand you.
I'm sure. No, what I'm saying is under Eileen's scenario, somebody contacted her personally. She said, I can't talk to you. You would have to send whatever you have to the committee as a whole. Now, let's suppose that person took their Facebook posting or whatever it is and sent it to the committee as a whole. Our job would then be to share it with the two parties and say, this came in. Either it supports or doesn't support either, but it's not, we're not judging that, we're just sharing it with them as another point of information for their case.
Transparent.
Transparency.
So, A
Unbiased.
calls me up and says, you really need to get the town clerk involved in this because she overheard the conversation. Under your scenario, I tell that person, put it in writing and bring it to the committee. The person says, I'll be glad to put it in writing, but I'll be damned if I'm going to sign my name. So we get an anonymous letter.
Wouldn't act on it.
Right, and perhaps the person, I don't know them, and they never told me their name, okay? So we get this anonymous letter that contains the information, you really need to call the town clerk, she overheard the conversation, or whatever. We have that now. Under your scenario, or Eileen's scenario, we then, Elaine's scenario.
You said Eileen, you were right.
Yeah,
You did.
So-
You
No,
got it
you're
right
right,
the first
okay.
time.
I'm
You were
confused.
good.
to change back.
You were good.
Under Eileen's scenario, we then called the parties in and said, we got this information, does either of you want to add the town clerk to your witness list?
I gotta make an edit to what you just said, because my recommendation would be to not even hear what the person is calling you about. My recommendation would be to say, as soon as a person was like, hey, Eileen, blah, I'd be like, oh, I'm gonna stop you right there. In my role, I'm part of a committee. If you have information that you believe the committee should hear, I'd like you to put it in writing, drop it into the Dropbox at the town offices.
Okay.
I'm not even having the conversation on the
Fine,
phone.
let's assume that happens, and it's anonymous.
Sure.
Okay? Now what do we do?
If it's anonymous, honestly, it would, depending on the nature of it, if it's hearsay, anonymous,
The entire statement is, the town clerk knows something about this, she should be a witness. That's the entire statement.
then I would leave that, I wouldn't touch it with a 10-foot pole.
If the person then further states what the town clerk, what he or she knows, whatever that means, the town clerk heard, would that make a difference?
No.
Nope. In this small town, if someone's saying the town clerk knows something, the town clerk knows we're having this hearing. The town clerk's gonna come to us and say, hey, you really need to make me part of the process, and then we get that and write
Oh,
it
whoa,
back.
whoa, whoa, now, so if somebody who is a witness, as opposed to somebody who said somebody else is a witness, if somebody who themselves is a witness comes before us,
The same thing, they put it in writing, we share it with the two parties, and they can,
but before you said you wouldn't share it with two parties if it were anonymous.
If it were hearsay, yeah, anonymous hearsay,
Hearsay.
but
This person comes in and says you should contact the town clerk because she knows something.
wouldn't,
that's different than the
That's-
town clerk
that's-
says, I have relevant information.
one of them is secondhand, the other is firsthand. So if the town clerk came forward, submitted to the committee and said, I have relevant
That's an
information.
ethics complaint from the
would-
town clerk.
You wouldn't even go to the town
Yeah.
clerk and ask her about this?
No, sir.
That's an ethics
not.
complaint from the town clerk.
That's true.
Yeah.
What do you mean?
If the town clerk came forward and said, I have information about such and such, we'd say, please put it in writing. It sounds like you want us to hear that, right? That's a separate,
It's a
I
separate
don't
complaint.
okay, I don't understand why it's
You- I
important
mean,
that it be in
like-
writing, but what happens
well,
once it's in
because
writing?
that's our process, right? To be able to walk through it.
You could
So
have it orally or
we-
in writing,
But
but
we could, to your point, we could get, right? So, we're all standing around an elephant. Describe your side, right?
Right,
So we could get an ethics complaint from 4 different people about the same issue
true.
from their perspective. We may be sitting at some point with an ethics complaint about one particular incident where 4 different people have a different perspective about it, right? Like that's common to happen. We
Yeah.
could get, and when we open our correspondence, 2 different people could be complaining or, asking us to evaluate the same situation, unbeknownst to each other, not even about each other, because they both felt passionately about whatever it is that happened. So I honestly, I think we're gonna have to decide how we are going to conduct ourselves as the information comes in fast and furious, right? Because more than anything, I think we've got to be clear on how we're gonna stand as a committee as the information's coming in, and how we're going to direct people to make sure that their information gets heard and that we process it in a way that does not bias any of ourselves entering into the position of having to hear it, right? So if I got pulled into a conversation where somebody, before I could even, get my arms around, like, hey, stop, cease and desist, I'd say, you know what, I can't hear this one. I've been tainted, right? Like, I can't come at it with a fresh set of eyes. And so, and it would be my hope that everybody would do that. That's just how I would approach it.
Okay, now let's get back to this. For some reason, oral versus written is an issue for you. The complaint comes in writing, okay, or the information comes in writing. What happens to it?
We go into non-public, we open it, we determine what we're gonna do with it based on the process flow that we've identified for everything coming in.
Yeah, I hear that, and what is, if we think the information suggests that a particular witness would have relevant testimony for this, what do we do?
It's not our role to provide supporting or negative information for the case to the parties. That would be up to them. So that, what I would do with it in most cases is nothing, other than, because our role in that is, it's not a request for a review of anything. It's saying, I want to give you prejudicial information on this hearing that supports one side or the other, right? Now, I understand your point is that they may have actual facts that would, if it were to come out in the hearing, swing the case one way or another, swing the outcome one way or another. Absolutely happens all the time. The appropriate thing for them to do, because as you said, this is a small town where everybody knows everybody in the complaints. If that person felt that strongly, don't you think that they would go to the person either filing the complaint or who the complaint was filed against and say, hey, you need to know that the town clerk was part of this discussion or whatever? That would be fine, because that's outside of the committee's room. The tainting has, or the line has to be not to allow the committee to be prejudiced one way or the other prior to the hearing. And again, we say very clearly that the burden of proof is on them, not us. We don't prove, we don't add to the case.
I'm sure judges all the time look at people coming in to state their case and say, boy, they'd be better off if they had so-and-so in here. But I have yet to see any of them say, why don't you call so-and-so?
And that's that's the problem I'm having. We're using the American judicial system as the model.
Yeah.
When it's an inappropriate model for what we're trying to do.
I
We should be
disagree.
using a European-type model, or maybe even a Chinese-type model, where the objective of the court is to elicit information and find out what the facts are,
I don't-
not to allow.
I wonder, it sounds like we're talking about two completely separate hearings. Is the hearing to say whether there was a relevant likelihood of a complaint? There is that complaint is relevant and it is an ethics violation, and we agree. Or is it to try the person who has been accused to see if they are true or not? Or they failed or didn't fail? And the reason the thing that just resonated with me with what Eileen said is we have 4 complainants coming in, four hearings. One of them passes, the other 4 don't because they don't have relevant information. That person still has an ethic violation, but the fact that those other 3 didn't meet the burden of proof because they didn't do that piece, didn't mean that person is innocent. We don't never have another trial because we've already had one, because we're trying to make that complainant whole, right? Is that the side that we're looking at as opposed to condemning or not condemning the person who was complained about?
To be clear, I would suggest we are not in the role of making the complainant whole. Our role is to hear the facts, as Neil said, that are presented, hear, witness, and then make a determination whether or not the rules, from our perspective, were abridged.
Based on that complainant's information.
Based on everything we heard, based on the entirety.
Yep. So I guess what I'm wondering is Eileen said we may have 2 complaints about the same thing. Are we then merging that into one giant trial focused on that person? Or are we saying we're going to hear each one of those complaints individually based on the information that they have?
Oh, now we're talking Georgia versus federal. But I would say that depending, if, for example, 3 complaints came in this week, and we just saw the building inspector, new building inspector, glad to have one. Let's say 3 complaints came in on the same issue about the same person in, the same official in town, then we might make a determination to merge those because it's the same moving incident. However, if one person said, I came in and had this discussion on Monday, and there was an ethics violation, in my opinion, and then I came in on Tuesday with a similar situation and felt similarly violated, well, those are separate infractions. If you speed today and you speed tomorrow, that's 2 tickets, not 1. So again, remember, at the end of the day, our job is just to determine whether we think the ethics rules in our town were violated and then put out a written statement supporting or,
But then
not
that gets to Neil's point, right? If we're just saying, we know that person screwed up, then we should be able to have the whole town come give their opinions, right? Or is it based on what that complainant presented, there was an ethics violation?
It's based on that. It's based on the complaint, because we
Right.
don't know anything.
Right.
And that is a sad state of affairs if we base our opinion knowing that there are other people who had important information, factual information, and we didn't hear them.
I agree. I'll tell you that it is, that American jurisprudence has some big holes in it. However, the other systems that you've identified are sometimes archaic and sometimes, violate our civil norms. We have to base all of our discussions on the rules that we have in our country, in our state. In fact, we quote laws from our state, and we talk about jurisprudence, burden of proof, and the levels of those here. We can't arbitrarily, as an ethics committee, create a new set of processes for outside of, entirely independent of the American legal system.
We are doing it within the context of the American legal system. We are trying to determine whether witnesses should be called only by the parties or whether other witnesses who, for whatever reason, become known to the committee should also be called.
I'm sorry, Neil, I thought I heard you say that we shouldn't use the American system that we might use in the European system or Chinese system.
I was suggesting that there are other legal systems that attempt to get the truth in a different way from the way the American legal system attempts to get the truth.
Mostly.
And they, in many of those cases, the judges have a very different role, a more active role in
course.
determining what the facts are than the judge in our cases, who, unless the judge is the decision maker, basically is an umpire, making sure the rules are followed, and the decision maker, the jury, makes the decision. In some cases, the judge is the decision maker,
And so.
somewhat different.
And so in the process that I submitted today, it anticipates that, in that you have to, one, have somebody who manages the hearing itself. Sometimes it may be the chair, it may be, as I suggested, you could bring in the town attorney, for example, just to oversee the conduct of the hearing itself, while the members of the committee are sitting there as the jurors, if you will, listening to the evidence and weighing it based on the rules as they understand them. So that's more into the particulars of the hearing itself. I think in this case, it would probably be the committee chair. But
The question is, I think, forgetting about judicial systems and all of the other somewhat extraneous points that I was making and that we were discussing, the question is, should we be limited to witnesses called only by the two parties, or should we have the ability to call witnesses who we think might have something to say on our own?
Right.
Regardless of how we may
And I
obtain
think-
that information.
I think we've covered that, and you're of the opinion that we should. I'm of the opinion that we shouldn't. I think Eileen's of the opinion that we shouldn't. I haven't heard from the
Yeah,
chair.
I am uncomfortable, and maybe that's just too much time on Facebook. I am uncomfortable that anybody who feels like they want to join in on this party's complaint can just reach out to me or send me a note and suddenly they're part of it.
Oh, no, I'm not saying that.
Okay.
All I'm saying is that, I'm not saying that witnesses can determine by themselves that they're going to be witnesses. I just want to, I think it's important for us to have the ability for us to call witnesses, forgetting for the moment how we decide which witnesses to call. But we, and I'm talking not about the witnesses who are giving the kind of information that you described before, the selectmen's process of decision-making. I think we should be able to have those. I'm talking about, in addition to that, witnesses who we believe have something relevant to say here that neither party has called.
So I guess the difference is.
Forgetting for the moment how we learn that.
I understand your position.
You're saying leave ourselves a flexibility, so as we're discussing, setting up the hearing, for whatever reason, someone sent us something in a non-public, we're talking about, someone really feels like we need to bring the town moderator in. Somebody decides that. We decide as a group, that would really be important, and it's part of the hearing, it's not informational. You would like us to have that ability to make that choice,
Yes.
which is different than anytime we go to hearing, we're gonna say, who else would we like here?
Absolutely not. We would have the ability to bring in others. Others could say you should, but they would have no right to be witnesses. We determine who the witnesses are, and we've determined so far that the witnesses will be those people who both the complainant and the respondent wish to bring in. We haven't in any way said that we're going to limit them. But if they want to bring in A, B, and C, and D, E, and F, those are the witnesses. I want to make sure that we can bring in G, H, and I if we make a determination, for whatever reason.
As a board, we decide, or as a board, as a committee, we decide we really need this person to enrich something. You
either-
want to make sure we have the option to
Yes.
discuss that.
No, that we have the power to bring them in, not just to discuss it. We can
No,
always
just-
discuss it. But I want our rules to say that we can do this. And there's another aspect of this also. Maybe I'm thinking a little bit deviously here, but, some people try to game systems. And they intentionally will not call a particular witness,
Yep.
because that witness may have information that they don't think is favorable to their
Sure.
case.
Yep,
The other side might not know about it.
understood, yep, you made
I
that.
want to make sure that we have the ability to call that person.
Yeah,
I understand your position. I profoundly disagree with it.
Okay.
I think I'm uncomfortable, I'm comfortable with leaving the back door on the rare instances where we know something. But I'm uncomfortable with making that part of the process. Anyone who is on Facebook is going to see things and be aware of things, and then we can say, we're not gonna read this, and we're gonna limit whatever, right? But if we're gonna go into a pre-hearing saying, who would we like to be there? I'm uncomfortable with that. So I guess what I'm trying to do is weigh both of your opinions. I lean more towards Luke's, but I understand sometimes you need to leave a back door for those rare instances, I guess. Eileen's looking at me like
I think the question, though, is to Neil's point, is whether or not we should incorporate into the rules the committee's ability to call witnesses independent of either of the
right, and
parties.
I'm not comfortable with that. That's why I'm trying to see if there's wiggle room for some rare instance, something, but,
Like I said, the only part of that I would be comfortable with is if it's a consultation with a subject matter expert, because we need a framework that we don't understand.
right,
Which is different.
Entirely
right.
different.
That's
That's
what-
not, that's not a
example,
witness
if we
per
are
se.
the jury, is what I heard as a model, right, is that juries don't get to call witnesses.
You
right?
don't get to elicit
You just
supporting or.
listen and,
But the juries don't get to direct the hearing, and we get to direct the hearing. So we're not just a jury.
True,
We're much more than a jury.
we're a quasi judicial.
We even get to write the rules.
yeah, yeah. So I think I'm hearing the majority is uncomfortable with us being able to call whoever we want as part of the hearing. We can share that information with the complainant and the respondent, right, if someone reaches out to us. We can have someone write something and we can review it in non-public and decide what to do with it. We can call people for information, but I think I'm hearing the majority is not comfortable with us adding in witnesses at the hearing point process, yes?
Unless, in Eileen's case, it's a subject matter expert witness.
Who we would have heard before the hearing. We're not calling them as a witness during the hearing.
And there might be circumstances where, for example, in a trial where you might bring in somebody to educate, everybody in the room as to a thing. But normally, I agree with you, normally it would be in the
But if-
pre-hearing, just to
You know,
educate us.
if I didn't understand the process, I'm trying to think of like an example that would work. I don't know, like election law, like if something was a law or a practice, right? Because there are things that are in statute, and then there are things that are practices, best practices, right? That different towns do. Trying to understand the difference between those and not necessarily knowing the nuances. I'd want someone who's a subject matter expert to be able to educate me in that.
As part of the hearing or in advance?
I would think it would probably be post-hearing, because I would, you know, if I'm stuck on that, I might need that piece of information to be able to render a decision.
Right. So you're not calling an extra witness at the hearing?
Nope.
It's someone you need for
It's,
extra
you know,
information? Okay.
it's me going through my decision tree and trying to come to a conclusion on something and saying, you know, I think I need a little bit more information about X to be able to make a clean decision.
I agree with that, however, I would add that it's possible that, you know, as we're contemplating the case, that we would want to educate ourselves such that during the process, we could ask intelligent questions of the witnesses.
Yep.
And
Sure.
so you might have it prior to, in other words, during the pre-hearing process, as well as post-hearing to clarify a point
Depending
that
on
we
when
didn't
that
hear
came up.
before, that was raised during the hearing that we need clarification on.
Sure.
I think that's,
So, we're saying we're gonna, So the people who will call the witnesses are the complainant and the respondent. We will know who those are at the pretrial. Is there, so we've had a pretrial, we've posted for a meeting, a hearing in 2 weeks. If-
Don't we need to put in here that the complainant and the respondent have the burden of bringing forward witnesses? I don't know that that's stated here.
that's in the process I sent out, it is. If you go towards the end of that, there's an actual process piece where they talk about the witnesses.
So, my question was going to be, we've had a pretrial, everyone knows who the witnesses are gonna be, we know when we're going to meet. In that period between when we posted the hearing and the hearing actually happens, someone declares, hey, I have another witness. Are we going to accept that person, or are they too late?
That would be on a case-by-case. Normally, you could amend, you know, add
Yeah.
an addendum, so long as it was done in a transparent way, both parties would receive the information
Okay,
and had an opportunity to object.
okay. So then, the witnesses will come forward. We were discussing, I think before you were here, that we would question the witnesses as opposed to the defendant would question the defendant's witness.
So that's, we hadn't quite gotten there, and so that's something that we'll have to determine, but again, what the processes I've been involved with would have the witness, or the charging party would bring their witnesses forward, they would solicit, you know, information obviously that supports their case, then the charged party may want to ask questions that would maybe, you know, support their side of the issue, and then we would have the opportunity to ask any questions that we individually had from the committee's perspective, that
So-
we go around and ask.
So kind of where, what Neil had described, he's here, he can say this, but the concern is if I bring my guys and I ask them what I want to ask them, and the other person asks counter questions, would it more become
That's,
more Jerry Springer-ish than if we've already had a pre-hearing, we know what the facts are, we know what that witness is supposed to tell us, so can we then ask that person to give that information?
I would respectfully submit that the person running, whether it's the chair or whoever you designate, would be in charge of making sure that Jerry Springer doesn't come into the room, that the questions are reasonable and relevant to the facts, that they're not, you know, salacious and all of those sorts of things, that you're keeping them in the guardrails of, we're here to discuss this issue, these facts, you either have information that supports or detracts from this,
But then
period.
we have that information, so why wouldn't we ask?
So are you, you know, you're talking about a couple of different frameworks, right? Like there's the framework, that's like a moderation style framework, right? Like,
Right.
ask me all your questions, right? Direct everything to me, if you're the chair or you're the moderator or whatever, right? And then you're the you're managing the conversation. It may be an exchange of information, but it's being managed by a chair, it's being managed by
A moderator
a
or something,
moderator
right,
or whatever. That's one style.
right. The other style is the defendant asks, well, the complainant asks the complainant.
Yep.
Right, and so I think that's something we haven't decided.
Sure.
And well, I think one of the, to Neil's point of wanting to get all of the facts on the table, I think that I don't see a downside of asking questions of a witness from both sides, and then from the committee's perspective, because again, those are biased.
Sure.
But the committee may have, and often has in my experience, no questions for that witness, because they don't, it's,
Okay.
the information relevant has been provided.
Okay,
So it doesn't generally devolve into where, unless you have people who are biased on the committee, and then they
Sure,
start
and then they
engaging
shouldn't have, yeah.
inappropriately, in which case your chair would,
so if I ask my own witnesses what I want them to say, if they're more comfortable, they know what to ask, and that will bring that information out. The other side then has a counter opportunity to push back, and then based on that, we can ask more questions.
right.
Okay.
And again, that's just one, there are multiple ways of handling
Sure.
witnesses. But at the end of the day, we have to ask ourselves,
Yeah.
we're trying to get to the bottom line of the truth. Did it or not violate
Yep.
these rules?
I think it would be much more expeditious and fair to unequal parties, and all parties will almost certainly be unequal, if they did not do the questioning, if we did the questioning. We've had the pre-conference, we know what they've stated what their factual situation is and what their witnesses are going to say. When it comes out into the room, when it comes to the public part of the hearing after the pre-conference, we should be calling these witnesses, not them. We should be asking witnesses these questions. We should be eliciting the facts. And there should not be cross-examination by one party or another. I think that's the wrong model. I think that gives one side an advantage, which is unfortunate. And again, I don't think it puts us in the position of attempting to find the truth. We're watching David and Goliath fight, not Goliath versus Goliath. It's a model that I think is inappropriate for an ethics committee to follow.
I think, I like the idea, and this one I agree with Neil, I like the idea of managing the discussion and the questions. And also, I think the work in between the pre-hearing conference and the hearing is determining to some degree, not completely predetermining, but having a structure of what the questions might include based on the topic that's been identified, right? So if the greater ethics topic is conflict of interest, or the greater ethics topic is, I don't know, pick something, you might have a sense of what the types of questions you are going to direct, you need to get the information about, right? So there may be a structure. Now, that's not to say that we won't get thrown a boomerang somewhere, but I think to some degree you have a sense of what is the information that you're trying to get to, like what's the fact pattern you're trying to establish, right? So I think to Neil's point, but I think the in-between there is statements, right? So asking, as a part of preparation to the group of people who are coming in here who are either, trying to refute or trying to prove, right? That, if you could put it to statement, whether it be bullet pointed, whether it be a narrative, however, if you could write a statement so that they have some structure, right? If that's at all possible.
There's a middle path, which would be that the committee would agree on a set of questions for all witnesses, present the same questions to each witness, and that would take away the Goliath versus whomever
Yep.
portion of that. There, I think, one of the inevitable things that happens with those line of questioning is you're gonna end up with the question at the end of, do you have anything else to add?
Bomb drop.
Right, and so, I do think it can be managed, because I do agree that what we don't want to do is come in here with powdered wigs and all of that, but, in maintaining some reasonable timeline. Again, I don't anticipate, based on history and based on my experiences in this town, that we're going to see a lot of these that are so contentious that we're, really into the mudslinging and all of that sort of thing. But I do think that would be a way to manage it, would be that the committee, in its pre-hearing information, could come up with a set of questions for each witness that they agreed on, and then those were presented at the hearing. Now, it would be a subject of debate whether those questions were provided to the witnesses prior to, or only in the meeting, and all those sorts of things. But I think that might be a way to manage it. That way, we're asking the questions, you don't have the back and forth between the two.
I think, I'm trying to stay at 30,000 feet to some degree a little bit tonight, because the nuances of all of the potential hypotheticals on this are hard, right?
Yes.
And one of the things that I'd like to build into the process is the opportunity to caucus.
That is anticipated in the process I sent.
So, because
Caucus?
to caucus, right? So caucus, us.
Us. To go-
Caucus in terms of,
We need to go into,
understanding our own direction, right? And understanding if we are, knowing that this is sort of new territory, right? And that, a lot of the questions that you guys are asking of each other and of myself tonight, I'm sitting here going, well, it depends.
Right.
It depends. It depends. And that, some of our process, right, we're gonna have to go to vote on. To this point, we've sort of agreed on most things. We've come to consensus on 98% of the things that we've discussed through a robust, really detailed set
Some might
of
say
conversations,
tedious.
right? Set of conversations. But we've had the luxury to be able to do that because there's been nobody else in the room but us.
Right.
And so the process that we've organically established with one another is the ability to have high-level, full-on conversations that we're not going to have the luxury to have when we have a group of people in the room. So I would like to build in the ability to break and caucus if,
Would that be non-public?
yes.
I would imagine so.
Is there the ability to do that in the
Yeah, why
law?
not?
I think there is during a hearing.
Why not?
Why-
So-
Does the law only says that we can go into non-public for certain situations, and
For
I don't know what
non-public for-
caucusing constitutes
For
that.
meetings,
For
right?
the meeting, I think the hearing would be an exception, we could certainly get a reading on that. But again, so I apologize, I didn't send out my suggestions until an hour or so before we got here, but.
I
if
was in
you-
another meeting, so I really
understand, you
didn't
haven't
get a
read them.
chance to, yeah.
But in that, it does anticipate that, and I can tell you from experience, that there are many times during these proceedings where the committee that's overseeing the hearing will say, all right, we're gonna have a breakout of our own here, all witnesses, everybody out of the room.
Sure.
We've got some things to discuss, and then they bring them back in, and that happened multiple times. And sometimes it happens because, for example, maybe somebody on the committee lets their emotions get out of control and, proceeds in a way that
Yep.
we need to just provide time and some discrete discussion offline. I don't think there's any prohibition under the law, though we could certainly ask counsel if that would be an issue.
Could you, Wendy, ask Naomi if the selectmen have ever been able to do something like that? Is there?
Do they
They're
hold
a different,
hearings?
but they're in a different process.
Do they hold hearings
They're
like
not
that?
holding a hearing, right? They're having a town meeting or a public meeting. It's a different, so not the same,
But don't they
set of-
follow the same 91A? Aren't we bound by that?
For meetings.
for meetings. So if we caucus, right, and we could caucus because let's just say, I mean, I've caucused with parties who were becoming, emotional or becoming, you know, skirting the line of it becoming inappropriate or abusive. I've caucused and said, we're gonna take a 5-minute break, and,
But you're not a public body.
no, but.
You're not
in-
subject to 91A.
No, but in this situation, if we're having a hearing, right, we can take a break during a hearing.
Oh, I know we can do that. The
Yeah.
question is whether or not the discussion that we have during the break is on Facebook or YouTube,
Mm-hmm.
or whether it's something that we do behind a closed door, as we will be doing, to get the complaints in to see whether or not there's a violation of 91A.
I hear you.
I think that would be a question for
Legal question,
council,
yep.
not for the Board of Selectmen.
Yep.
So if we can caucus during a hearing.
You use the word caucus. In the legislature, there's a special provision in law that says when a party, a political party, the Republicans or the Democrats, one of them's in the majority,
Sure.
when they hold their caucuses, that is to say, a party meeting, that does not constitute a violation of 91A, and it's specially written into the law.
Yeah.
You use the word caucus, and maybe I
It's
got hung up on
probably,
that.
yeah, it's a language,
It's not called a caucus in the guidance I sent out.
yeah,
It's called something else.
Sure.
It's just basically a
break.
breakout is, I think, what they call it.
Breakout, yeah.
But
Breakout as opposed to break, because breakout, you can go off on your own
Right.
and have a small discussion and come back.
And I don't care
and
what
you
we
would-
call
You would
it,
have
as
to
long
identify it
as-
as something like a non-public breakout. And again, you would probably do that under the cover of council and say, is
Oh,
this appropriate?
we're gonna have council here?
No,
No.
Neil, what I'm saying is.
Whatever
that
we
prior
decide, we need to-
We would ask council if that were appropriate in response to the requirements of the RSA.
I think that's a good question to ask council. I'm trying to recall which provision we might even
Well, I don't know
consider.
that the non-public options for a meeting are relevant in a hearing. Is a hearing,
We call it a hearing. It's a public meeting of this board.
And again,
We couldn't conduct the hearing confidentially unless there's a specific exemption in the RSA for,
point of order.
well,
Yes.
reputations.
So,
Well, you know,
so I think we have a valid question.
Yes.
I think
Yes.
we've discussed both
Yep.
sides of it, and I
Yep.
think that we need to refer it to council
Yep.
and then move on for now.
And I mean, you know, and part B of that could be that we have a break and we don't discuss
Anything.
anything. We just have a break.
that we
To
can
what
do.
end?
Defuse.
5-minute break.
Defuse a,
But
Again,
what's the purpose of the
in,
break?
in the process that I sent out belatedly, it also anticipates that the parties themselves could also
Request a break.
request a break for any number of reasons. I have to go to the bathroom.
Yeah, or
What's
I
been
want to
going on?
talk to,
Or I want to privately
Yeah.
consult with someone, whatever those things are. And that the committee also would have that ability to call a break.
We could certainly call a break in the proceedings, but I thought your point was there would be some sort of discussion amongst committee members during this break.
it's a both end. So it's getting the answer on that question from council as to whether we can do that and what the rules are.
Discuss.
And- Yep. So asking town council, what are the parameters with that? And if that would not be appropriate, right? So like, let's just say that's off the table, still putting in some sort of provision that we could break. Not to discuss anything, but that if somebody needed a break, whether it was us or somebody else.
That doesn't need to be in the rules. The chairman can call a break whenever she sees fit.
Yeah, the chairman can.
That's right. You
But-
can't.
But that's what I'm saying. So it would allow me or afford me the opportunity to say like,
And so I think that really the definitive point on the break question is the chairperson could, by request, if I requested, can
You
we have a
can, I was
break?
gonna say,
Then
you
the
can.
chair could call one. The same thing could happen from, so it may be to Neil's point, that might not be necessary.
Yep.
Because anybody could ask the chair, and the chair could rule whether or not a break was appropriate.
sure.
So I think that's already there.
I guess from the perspective of people coming in and not understanding what the rules are in our process, to be able to make that clear that they have
Sure.
that power and ability to request that would be something that I would want implicitly
It
stated.
certainly would be a good idea for
Yep.
the reasons you said to put it in there. The committee may take, Ethics Committee, the committee may take a break from time to time as the chair sees fit or something like that, sure.
And as a complainant or defendant, they have the right to request a break.
And it is a really good idea to leave it up to the chair, because they could also attempt to gain
Like
the
a timeout to
process.
gain yardage,
Yeah,
to stop momentum?
right.
Yeah.
Or to go call, they're losing, so they want to call 5 more friends to come.
Yeah, or just to break the momentum is the thing I've seen in the past, where you want to break.
You just raised an interesting point that we haven't discussed, but perhaps we ought to. Are we suggesting that at any time during the hearing, either party could bring in more witnesses?
I mean, like a Perry Mason moment where we're like, I don't know that we can, right? Because,
We can do whatever we want, we can set the rules, the question is, what should we do?
I would suggest that that would not be acceptable, and for them to try and bring a surprise witness at the 11th hour, that barring extraordinary circumstances, that would be inappropriate, and the chair would rule that's not acceptable.
Yeah, well, my witness, because of the rules that you guys decided on, the person who telephoned me changes his mind and telephones A or B. In 2/3 of the way, you really ought to call the town moderator because.
Sure, and
And so the complainant comes in and says, I'd like to add another witness to my list, the town moderator. Now, do we want that to happen or not?
again, that's really case dependent, and I think that the chair is already empowered to make those calls, to say, that is not according to our process, or in the event of an extraordinary situation, that they could say, all right, that is relevant
And should we
information.
put that in the rules for the same reason?
I don't think, one, it's necessary, or two, it would be helpful, because I think what you end up in potentially doing is just starting to show the back door to getting around.
So we want to put caucusing in the rules, or putting a break in the rules, but we don't want to say that additional witnesses can or cannot be
Well,
called.
I wouldn't characterize it that way, because as I said, I don't think we need to put the break in the rules, because I think it already exists. I don't think it's necessary to articulate. I think Eileen's point was that in the instructions to the people coming in, them knowing that the chair has the ability to call a break, and that if you're looking to request a break, you would ask that of the chair, is just an appropriate procedural.
so for example, when we do deliberative session or whatever, you go over some basic Robert Rules of Order. And so that's just educating people if you have,
Here's how we're going to proceed.
right? And so as part of those instructions, it would be.
So don't you think it would be appropriate to say, no additional witnesses will be allowed except under extraordinary circumstances, or something to that effect?
Appropriate, no. I don't, because appropriate suggests that without it, we're acting inappropriately, and I don't think we would be. I think you could, I think it's something that the committee could choose to do, but I don't think it's necessary.
If we're going to have procedures that we think are important to us, and we're not going to tell everybody what those procedures are, isn't that?
I didn't say that we wouldn't tell them what procedures were important to us, Neil. What you're suggesting is that we might have to go into such detail about the proceedings that it becomes cumbersome itself, just in understanding those. Whereas normal process for committees, traditional process, allows for the chair of the committee to do certain things in any committee setting. And it would be typical. Now, we could articulate all kinds of things to the folks. Some of that might be helpful, some of it might not, but we could also simply say, should questions arise during the process, those questions would be directed to the chair, and the chair would take them under advisement and make a determination moving forward. And that would cover all of those things.
Yeah, I think sort of getting back to Eileen's 90% rule, we can define the basic high-level things. We're going to basically, when we start a hearing, give some basic rules of order and basic, if you need a break, here's how you go about that process. That's different than saying, here's all the different edge cases. And I hear what you're saying. I mean, I think if we're going to have a guidance that says you need to, if you're going to call a witness, you have to tell us so far before the meeting so that both parties are aware. That's a reasonable rule if we decide to do that. If we're going to have, though, exceptions that for our Perry Mason moment, for whatever reason, and we need to have a back door for that, you can't document all the back doors.
Well, to your, but to your point, Wendy, right? So we know that, when we're posting meetings, right? Was it 24 hours?
24, 48, one of those, I can never remember.
So my question, or a question that I would want answered, is do we have to follow that standard for this process? And do we have to have an outlined agenda form?
Oh, okay.
Like, who's gonna be there, right? And so would that set the parameter on what the cutoff time would be? And I don't know the answer to that question.
I'm sorry, I'm not sure I understand the
So
question.
when we post a meeting, right, like even posting this meeting, is it 24 or 48? 24. We have an agenda that gets posted, and we say, you know, the ethics committee's gonna meet, we're gonna be doing this stuff tonight.
Right,
We warn the public, it's our responsibility,
so that they can attend if they
so
choose
they can
to.
attend, and they know what we're gonna be talking about roughly.
Right,
It's our responsibility, we have to do that.
of course.
So we list the witnesses as part of the agenda.
So do we have to warn the public, right? So we're gonna be dealing with this particular complaint. This is the group of people who's gonna be here, so the list of witnesses, would they have to be a part of that 24-hour notice? And I don't know the answer to that, but it would be a really good
Would-
question for council.
Would the witness have to be, are you asking, would the public have to have the understanding that these are the witnesses?
No.
Well, I'm saying, like, is that the cutoff?
All you need to do for the notice to meet the statute is say, we're having a meeting and there will be hearing of Jones's complaint, number 54, and Jones's complaint number 54 is a public document.
Yep,
And they can come and get it either online, however it's done. No, you don't need to have witnesses, list of witnesses on the notice of a hearing.
okay, so then my second point of, and this is just operationally, right? So if we're at the pre-hearing conference and we say, all right, you know, tell us what your stuff is, and who
And
do
this
you
is,
want?
this is online now. I mean, this
Well,
is
no,
public.
we're like having that conversation with the people,
But
right?
this
Like,
is a public
yeah.
meeting.
Yep, and we say, okay, so who are you bringing, you know, to prove your point? Who are you bringing to refute that point? That's how we know how much time to allocate, right?
Fair.
So would that be sort of part of, like, our procedure operationally? That we need some advance warning if there are 5 more witnesses, because we need to build in the time for the 5 more witnesses, so that if we had 2 things that we were dealing with that night, we would have ample time for both.
So,
See what I'm saying?
Sort of, I think that, what I envision is that in the pre-hearing discussions, we would know the witnesses at that point,
Yeah.
and then we could structure the length of the meeting accordingly.
Exactly.
Is your question,
So at
After
the
that,
11th hour,
they come in and they say, I want
they
to bring
say,
in
listen, I
5 more
got 5
witnesses?
more people,
Right,
I have a family of 10 out in the car, and
Yeah.
they're all coming in.
and then, no, I mean,
Right, so but that's my point that I'm trying to make is,
Right.
so the cutoff for us operationally is to establish the amount of time we believe that they're gonna need, right?
right,
And so if they called us and said, you know, we have 10 more people, wouldn't we then say, okay, but we can't hear you tonight because we don't have the time for that?
I think that would be, well, there would be one of 2 things. Either you would say no, because we've already established the rules and, you know, and all of that, or we would defer the hearing to a later date.
Yeah. But that being sort of the why of
Right,
managing a
sure,
witness list.
absolutely.
So it's not,
right.
right, it's not personal, it's not, there's a reason, and it's logistical, and it's not.
Yeah.
Yep. So I like the term operationally. So operationally, when we get through the pretrial hearing, we know who your witnesses are, we know who the other persons are, everybody knows who they are, we agree on what the complaint is, then we're just gonna go hear those witnesses
Yeah,
as
that's
part of the
fine.
hearing, right?
Something major changes, then it may change the,
The amount of time, if you're bringing in 10 more witnesses, then the other side says, oh, well, I need to come up with 10 more witnesses, and it just gets postponed for,
yeah.
I like that.
And I would just submit that it would be an extraordinary exception that the committee should allow for that kind of inflation of the witness
Sure.
list,
Yeah, yeah,
because
yeah.
in many cases, that would just be an attempt to defer the discussion.
Correct, and so it's a discussion, like, they don't automatically get to delay it, right? We
Right.
need to have,
That's our call. Specifically, your call.
but we already know what the issue is. We know if we have sufficient witnesses to give us that information, like we know 5 people who are present are going to come and talk. Do we need 15? Like, we have that sense before they declare that.
Well, and also, if we've made the determination that we're going to come up with the questions, and one thing we could do is solicit from the parties, what questions would you like to ask? And then, we could consider and maybe add those to our list. Then we would know how many questions there are with the,
Per
that would give
person,
you
like how
a
much time,
better
right, exactly.
idea.
Right, so a school board, right, if we have 20 people talking en masse, then we have to limit discussion to like 2 minutes per person, so we're not there all night, right, so.
And you can also consider that a hearing doesn't have to be started and completed in one session.
Sure.
That if there were such a list of witnesses that it's not practical,
Yeah,
you could,
I mean, it doesn't have to be, you're right, I just wonder if the complainant has given his entire side first, his or her, and then we end for a week, I've forgotten my name in a week, right, so.
yeah, I understand
Right.
that is absolutely something you'd have to take into consideration during the case,
Right.
you don't want to.
I mean, we can break it up at pretrial and say, we've got so many people, we're gonna have to do this over a couple. It's true. Okay,
So I would suggest, I think we've had some pretty decent discussion tonight, I would suggest that we go back and consider the submission that I belatedly put in.
read through that.
And read through that, and then see if it's, if there's a way for us to slice and dice, or just say, no, we're not gonna use any of that,
Right.
that doesn't make any sense, whatever, but I think that what we're looking for is the actual hearing procedures for
right.
the hearing, not the 30,000 foot, how are we gonna do this when, the rubber meets the
Right,
road?
and yours is very deep, like, I tried to cursory over it, and I can't read it in 5 minutes
No,
and get it all
is,
right.
and again, I apologize, I had to
No,
go back
that's
and.
fine. So, I think that makes sense. I think the goal, though, will be to try to come up with a process that, for pretrial and for trial, because once we have that, we can start, like, I feel, to your 90% rule, I think we can talk ourselves in circles for like the next 3 years until we all burn out and we go away, right?
Can't miss good on the way to perfect.
Right, right. And so if we can get a 90% process that we're okay with, I think we're gonna have to try it. Right? And so just in your own mind, get your head around like what you would see as a pretrial.
I know I was late tonight, and I hate to ask this question because I was late. So, did we decide, or did this group decide if we were good with the first 2 sections? Like, did we say, yep, we've blessed this, we're moving on, that's all set, now let's focus on this?
Yes.
Okay.
Tentatively, yes,
Tentative.
but we didn't take votes or do
We didn't
anything
do.
formal.
I just said, did you all agree? And they said yes. And I said, okay, so we're good. And they said yes.
Okay.
But it wasn't like a vote or a,
And I think, we have not done it yet, and I made reference to that earlier. There have been no motions that have come since
No.
we've begun meeting. It's been a lot of discussion, which I've appreciated. We may have to get to the point, I think, in
We're
the
gonna have
next
to start
meeting or so to
knocking
dial
some
down.
things.
Codifying them, and
Yep.
I think that's an excellent point, and I would suggest that maybe the chair come with a list of things that we've already discussed, and we
Vote
go
through
through
them.
and vote through them,
Yep.
and get them down so
We-
we can move on.
We've started, or at least I think we can have a starting point to do that if you look at the documents that I gave you.
Exactly.
As far as I know, these are up to date and reflect everything we've done. So we could actually vote on those, not tonight, after you guys have had a chance to
Sure.
read them and say, oh, no, this is wrong. Now, obviously, number 5, the one we're discussing now, is
Yeah.
something that's that needs to be revised. So for next time, Luke, what are you going to do with your submission, and what are you going to do with number 5?
All right, so my submission I've given to all of you for the feedback part. I don't know what the appropriate process for the feedback and the slicing and dicing of that is moving forward.
What if, I'm just gonna make a suggestion, we each, red letter it at home and come back, with
Our concerns.
like a rough,
Well, as a result of tonight's discussion, shouldn't Luke go back and revise this to reflect our discussion?
I'm not sure that our discussion narrowed that.
Oh. Oh.
And I wanted to issue sort of a challenge to us if I could. Is that, what's today, August
16th.
16th? I would love to be able to come forward with a package by like this time next month. Like
Yes.
I really would love to.
Yes, and I think, and that's kind of why the last agenda item in was the September schedule, because I feel, and I told this in its feelings, and I told Luke before this meeting, I feel like we could deflate talking in circles and not sort of getting to the next point, so I think we need to have something codified, whether it's perfect, ratified, whatever, but by the end of September, so that we can start having the rubber meet the road. I think that's reasonable. And so with that in mind, if we're going to have, I'm transitioning, because if we're going to do that, we have we have one more meeting in August, so we have 4 meetings. Within 4 meetings, we need to have ratified our full process enough so that we have a package so that we can communicate it and we can start.
Our next meeting is next week?
Yeah.
It is.
So keep that in mind as we go forward, because the discussions are amazing. I've learned so much, but if we're going to finalize something, draft version 1 in a month, we need to sort of focus, so.
So, to facilitate that,
Yep.
what documents must we have for next week?
Right, so,
Luke has done some work on this.
yes?
And to your point earlier, I retract what I said. In reflecting just now, I think there are some things that I could change, so I will come forward with edits as well to specifically address the witness part of
Could
that.
you do that tomorrow so that we get it, so to speak, on Friday or Saturday or Sunday?
Well, actually, Neil, I think what we were discussing is everybody would do that. Everybody would redline their concerns, and then we would come and mix them. I could go back and adjust it to say, we talked about this witness and this witness, but what that's gonna do is kick the can down the road such that now we look
Just
at
dragged it out another week. Yeah.
just those and not, I mean, we all know that we've talked about changing the witness process, and so that we could just strike that part in my suggested outline about having the parties interrogate the witnesses and leave that to the committee. And we know that we're adding, that we may, and I don't know that we got consensus on whether we wanted to come up with our own list of questions. So that's something that we could consider and bring forward at the next discussion.
If we don't have an updated document, our next discussion is not going to be productive.
I agree. On the other hand, everybody needs to have input to it, and I think it's, my assignment, as I understood it last time, was not to write a process for the group, but to share a process that I had experience with, which is what I've done. I think it would be presumptuous of me to put forward a whole set of proceedings, but I will defer to the chair and the committee on what they want me to do between
After
now and then.
tonight's discussion, I think someone has to do that, so we have a starting point. And that has to be given to us in enough time so that we can read it, and so when we come to the meeting, everyone can say, we're agreed on 17 items, but on the other 3,
So I hear you, and he needs to do work so that we can reflect on it, so we can do something. The things that we need by September are a process for inquiries and written. We need a process for our getting to pretrial, what our pretrial hearing process is, and then what our hearing process is. And then the rules, because we're conflating a couple things. The process is the process, and then there's the rules and who can do what and how we're gonna handle things, how we communicate things, and what we're gonna allow and not allow is a separate body from what we do, I think. Because this process is great, right? It's like, we're gonna do this, then we're gonna do this, and that's independent of who can call a witness, when can we caucus, I think, you know.
So Neil, what I can do and will do is I will go back and review it and try my best to edit it from my understanding of tonight's discussion. And I will share that hopefully over the next day or so. Definitely before the end of this week, that this is my understanding of the changes that we've discussed and just.
So we'll get a revision of this?
You'll get a revision of that.
Okay.
Okay.
And what about this? Is this something that we need to revise now, or does this depend upon this?
Well, I think part of what that depends on is some of the questions we have for council, right? And I do think that that's a separate, I mean, as far as revising, we haven't even opened the discussion on that document, because as I said earlier, that's pretty heavy on the legal perspectives, the burden of proof and all of that. And I'm of an opinion, but I don't think I should be, redrafting that as an individual. I'm not sure my opinion is that.
So you think that this is really independent of this?
Right, what I think is one of them, so in my experience, what we had was one article of the Constitution dealt with, if somebody has this complaint, here's how you begin the process. And then what would happen is when it went to a hearing, there would come out a process for the hearing, for the specific hearing on that case, because some things are not specifically called out in the Constitution. But
Okay, now, once we get Luke's document, what can we do to speed up the process so that we can move forward faster at the next meeting? For example, I understand it's legal for him to send this to us.
So my recommendation about how to proceed,
Yeah.
if you're asking me, would be to have Luke do that, to come into the next meeting, to look at the body of work we've already done. Not Luke's work, but the body of work we've already done. And say yes, 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 and actually have a motion on that first
Close
section.
those down. Yep.
Close that out, move that forward. To have a working session where we look at the document that we've taken some time with, that we received from Luke, and then on our own, taken some time with, to come to some consensus, right, about what, and I, like, my personal opinion on this is that the bulk of the time should be spent on operationalizing the pre-hearing conference, because I think between our first pre-hearing conference and our first hearing,
90%
we're
of it
gonna
will be.
have to sit down and say, okay, how are we doing this?
Correct, yeah.
So, it's sort of building the boat as we're sailing, but, I think that spending the bulk of our time understanding the parameters of our pre-hearing conference process and operationalizing it so we all understand what's gonna happen. And then taking the time before our first hearing, we may need to build a session in between the two. One, to develop questions, two, to really understand our process.
So we could have a scaffolding process for the hearing,
Yes.
right? But to ratify it, we're really gonna have to have gone through the pretrial to see what we're at and what we need to do.
Yes. And also in there, my suggestion would be to get our question, once we have a process document, right? And to use your term, scaffolding document, the questions that we have about our own process, we've got a body of questions now. We've gotten all the way through here and we're like, we don't know the answer to this. That piece, I think we should see if we can be afforded a couple minutes with town council to say yes, no, yes, no, yes, no. You can do this, you can't do that. Here's a suggestion, right? And then we can come back and really frame it out. And I think that's a reasonable amount of work in the time frame that we're talking about.
In a month, or, yeah.
Yeah.
Yeah, so within the next meeting, we will have,
So, translation in my language, we're gonna vote on numbers 2 through 5 or 6 or 7 or whatever the numbers are? Is that what you're suggesting for the next meeting?
I don't know that so,
If there's something else that we haven't,
no, so I think we already said that, I don't know that facts is something we can, and ethics concerns, like, I think we got into process I thought some of these we got rid of, but maybe not.
We haven't voted on any of them.
Right.
So we would need
Okay.
to vote for each of
Okay.
them. But I think, to Neil's point, I think the first four, we're definitely ready for. The fifth one is one of the ones that's under discussion now.
Right.
Yep.
Right,
So-
yep,
Yes,
yep.
yep.
So the first four, I think absolutely we could come in next week and vote, and move those along without objection.
Ooh, yeah, I guess, okay, all right.
It's a suggestion. You're the
No,
chair.
I hear you. My concern is, do we need, like, and I guess that's part of the vote, do we need a frequently asked questions?
But though
Do we-
that's really at the end. I put that out there because I think it's important for us to have some sort of document in English that people can understand.
Understand, but I can't vote on that particular one if
I
we don't
agree.
need it, right? So,
That's
and one
at
of
the
these
end.
is, process for, so
And
you
the-
have a process and Eileen has a process, so why would we vote on
Wait a
both
minute,
of
this is
those?
Eileen's process.
No, this one is your process, number
Number-
6.
Number 6, hold on. Number 6.
N- She had an internal
This,
document.
yes, this,
Wendy, they may not, I sent it to you, I didn't send it to the entire.
I got, yeah,
No, you did, it's number 7, right? It says from
this,
Eileen.
we discussed this.
right, but then Eileen wrote a process, and so,
She wrote, and her process is number 7.
Right, so the question is, how do we marry 6 and 7?
yeah, that was my question.
Oh,
So I thought 6 was replaced with 7. So, I mean, we can,
I think you're right, and I do think that's something that we'll have to,
when we vote through them, we can go
as
through it.
homework, we might want to compare the two of these and see, do we really have one document, or is it required?
Right, and
two
so,
required?
number 1 is an agenda, so that's not gonna vote on, right? And so, the process for,
so 2,
Yep.
3, and 4 we need to vote on.
we need to have, yep, we need to
Well, we're
ratify and
ready.
be done with them.
We're ready to
And-
vote on those, yes.
And I thought 5 and, or 6 and 7, however you want
I
to,
think 7 we're ready to go, because that's the internal flow that,
but the C is missing. which
Because we
is-
didn't get there yet.
Yeah,
table pending further discussion. So you don't want to vote on what we have currently, you want to
Wait till it's.
vote till it's done, okay, all right, that's fine.
So then, what I wrote for a note was, compare 6 and 7 and merge, and that would develop.
And so if we all do our homework,
so I'll try to merge those.
I think we were talking about everybody redlining stuff, so certainly we'll all come together with our views on that one.
Can we all come?
Yeah, I know, we're out of time. Naomi needs to get some sleep once in a while, so. All right, so next meeting, I'm gonna have a list of things that we need to, a checklist that we need to complete by the end of September. We're gonna focus on the pretrial, well, we're gonna start with voting on what we think we can get banked. Then we're gonna focus on the pretrial, right, and get that process sort of agreed upon, knowing we don't answer every question in the world. Yes?
Yes.
Okay.
And
So-
then hopefully walk out of either that meeting or the next meeting with the list of specific items and the packet that needs to be vetted so that we
We need the
can-
specific questions for the lawyer for September,
Yes.
yes,
That
early
would be my
September.
suggestion.
We need those questions because we can't ratify the packet until we've dealt. Got it.
Motion to adjourn?
Yes, do I have a second.
Sure.
All in favor?
Aye.
Aye.
No.